You are listening to the Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Toni and Cheryl. Toni and I are two Texas licensed attorneys, and we have the show The Legal Connection as a public service to our listeners. So thank you for being a listener, and get your friends to listen. We address legal questions. We answer questions that you send us and questions that we're asked. You know, we have people come up to us all the time and say, hey, you do that show, right? Well, talk about this. And so today we're going to talk about homeowners association. This is the third part in a non-consecutive order. But we've had some more questions and incidents with homeowners associations.
A number of my clients had more questions, and like just with last week's show, one of my clients, not just one of them, actually several of them had questions about easements and some issues they had, and they knew it was really expensive to hire an attorney, and so we answered those questions for them last week. And this week, I would say I have about maybe 5 clients that, even though I do, there's a broad spectrum of the type of law that I practice and that we practice,
right.
In our type of law. I don't want to say career, but just in our law practice. I do criminal defense and the whole gambit of things.
Family
just so
law.
happens. I've had a lot of questions with regard to homeowners associations and people, being fined by them, and they're really afraid. This is their home, and they don't know quite what they should do under the circumstances. And do they mediate? What kind of power do they have? Can they fight? Fines? Were the fines that they were getting, were they valid? I mean, lots and lots of questions. So that's what we're going to do today. We're going to answer some of those questions.
Okay. Fine. So homeowners associations, if you didn't catch our last 2 shows, non-consecutive, it was a couple of weeks ago, about homeowners associations. I just want to do a brief background that homeowners associations, they're called HOAs.
And POAs.
And POAs?
They can be, HOA is homeowners association. It can be a property owners association. It can be a condominium owners association. So there's different names for it, but it's the association that governs. It's a group of people that have come together, and usually they're nonprofit corporations.
And usually they're volunteers.
And they're usually volunteers.
Right.
Sometimes they can be, I would say that the ones that I've been members of have been managed by management companies, but several of my clients did not have management companies. They were handled by people that were actually members of the group, but they're called different things, and they manage where you live, basically.
Okay, and they share a common purpose. They manage and take care of the common areas in a neighborhood. It's run by a board. It's typically, as we just said, made up by volunteers and fellow owners. Depending on the size and how extensive a role the board takes, a board may be organized in committees. The board can be incorporated.
Yes.
And that's something that's important for you to find out when you're considering moving into a neighborhood.
Yeah, we had gone over all the things that you want to look at, because they really do have a lot of control over what you can do. And the, a lot of the case law that I've read, and I'm sure a lot of people are familiar with this, the smallest things can become something that is the impetus for, major upheavals in a lot of money. And we're talking about homeowners association arguing that the number of panes in the window when it's being built should be 4, instead of 8, or, that small. And it goes into, hundreds of thousands of dollars of legal fees when the homeowners association says, no, you're not complying with the deed restriction amendment. So, the deed restrictions. And there's 2 things you want to look at in a homeowners association. First, when it was formed, how it was formed, if it was properly formed. And then you've got your covenants, which is your use restrictions and the things that tell you what you can and cannot do. And then you got your bylaws, and that tells you basically the government, that tells them what the rules are by the people that are in charge, what they can and cannot do. Okay, so the bylaws are sort of the regulatory rules, whereas the covenants are telling the people what has been established to protect their values and be a part of the community and that kind of thing. So a lot of this goes to what's reasonable. Just I think in life, what is reasonable goes towards so many things that we have to assess. Just like right now with the Supreme Court justice nomination.
Yeah, Kavanaugh.
The whole thing going back and forth with what is reasonable, and
Right.
you've got both sides of the argument. We got the accusations on one side by this lady that are unfounded to the extent that there's no corroboration other than she said it happened.
Right.
30 some odd years ago, nearly 40 years ago,
Mm-hmm.
and then you've got the people that are saying, well, this has happened to me 40 years ago, and we can't have somebody that's like this on the board. He's probably some kind of predator. But that being said, what is reasonable under the circumstances is up for, definition. All right. So we're going to ask, what does reasonable mean? Because these little things can get completely bent out of shape. And I will say this, of a lot of the homeowners association arguments and things that have come up, they tend to be, for the most part, and I think you might have some input on this, they're small. For the amount of money involved, they're really small. For an example, there's a lawsuit going on right now with a lady in River Oaks who wanted to add just a little bit of concrete to her drive so that she could have wheelchair access for her mom. Okay,
Right.
just on the side. It wasn't like in front of the house. It wasn't going to, significantly change the way River Oaks is viewed if she added just a few feet and so it was flat for her elderly mother to have access to her home so she could live with her.
Right.
And the Homeowners Association Architectural Committee said, no, it's not in compliance with our deed restrictions, and you should have thought about that when you built the house, although this was a circumstance that didn't exist at that time. And so she hired some really good attorneys, like the best you can imagine out in River Oaks, and has been fighting it. Really, really wonderful person, does charity, all in all, wonderful person, okay? And doing the right thing by her mom, doing all the right things that you would want to do, or you think you should do. Well, the Homeowners Association said no. It's gone into protracted litigation because she's saying no. I say I should be able to use my property freely and put a wheelchair access if no one can see it, or if it's on the side for the hardship purpose of for no other reason. Even the government would allow that sort of a they shouldn't be discriminating against the handicapped.
Disabilities, right?
What they did was they said there was an amendment that prohibited that unless you had only so many square feet could be concrete, and they said you've extended it by another 15 square feet or whatever it may be. It was some small amount. And what they did was they attacked the amendment from the standpoint that it wasn't properly passed back in, I want to say 2005 or something. And the Homeowners Association, being the controlling homeowner association and digging their heels in, said, no, it was passed properly. And so they subpoenaed the records to see the ballots, and they wouldn't give them up. And they went all the way to Supreme Court, unbelievably. And the Supreme Court said, yes, you have to release that information to see if it passed.
Good.
And it's actually still going to trial, even though they have the information that shows through their expert that it didn't pass. She should have her wheelchair access. The fine should all go away. They're fighting over something that economically makes no sense. I mean, clearly the association is going to lose on this one, in my opinion. It hasn't gone to trial yet, but it will. I might go watch that one. But we're talking about, like another example is another one was in Houston, where for many, many years in the Southampton area, there were, if you're familiar with Houston at all, the area over there by Westview has alleys, and that's where their garbage pickup is. And, such an expensive area that that they've used up every inch of space. And so this guy buys this property, and he decides he's going to decorate. He's going to put a little 3-foot garden in, something I would definitely do. He put a 3-foot garden in to make it pretty back in the alley, where there are some poles and some electrical utility meters and what have you. And the Homeowners Association said, no, that is a utility easement. You cannot put your little garden in there, even though there's other areas where there is already
gardens.
There's not space anyway.
Right.
And they are split on this one, but in this particular decision, they said, yeah, the deed we don't care what other people are doing. The deed restrictions say that you can't do that, and so we're going to fine you. On the other hand, the complete flip side in another case shows that we're just two people out of how was this? Which way did this case go? It was there was a subdivision in Meyerland, and there were, I think there were 1,500 different people that had lots in Meyerland. They're all different sections, but the bottom line was, they weren't enforcing the deed restrictions. They weren't enforcing them with consistency. And this guy said, "Hey, I should be able to, park my RV in front of my house and move it from time to time when it's not in use, because other people are doing it, and you're not coming down on them, but you're coming down on me."
You're picking
and
on
they
me.
said, "No, you move it periodically, and it starts over when you park it again, and we're telling you to stop. You can't do that now." And ultimately, he won. They said, because you haven't enforced the deed restrictions
That
against
makes
everybody.
sense.
And it was protracted litigation over something really small. Parking his RV in front of his house when everybody else in the neighborhood was doing it
Right.
out in the older Meyerland area. So I guess that's when you have to go to what's reasonable. What's reasonable for the homeowners association to come down on you, and what's reasonable for you as a homeowner, because anything you do may come out as a cost to your homeowners association. So you all try to be nice. But what the problem you're going to run into is if the association is sort of improperly running up attorney's fees to make you look like the bad guy,
Right.
so that you
Like you're hassling them.
yeah,
or
like
harassing.
unfounded. Like we're gonna ask the attorney. If you ask for any records from our association, then you need to go talk to the attorney, and that's in another attorney fee for the entire association.
Right.
Or yes, we've been doing this for the last for the last 5 to 10 years or whatever. A number of people have been on the board, but we still don't know what our deed restrictions say, and so
Right.
we're going to, for every question, we're going to run it past the attorney. And then that person that just has a question about maybe wanting, a 4-H pet, something that clearly is proper under their association rules. They're now the bad guy by asking for, just a question. So the question is, what is reasonable under the law? And reasonable is, what does it mean to be reasonable? It means understanding the authority of the association. Okay. Knowing when an association should take action. Very important. Knowing when an association should not take action. So, and what is permissible action by the association? This isn't always something that needs to go to the attorney, but we all know that if somebody just wants to do something really simple, like paint their house a shade of gray that's slightly different from the shade of gray next door, when everyone's got different shades, the association probably shouldn't take action on that.
Right.
If they do, you have to kind of worry about it. So those are the questions you asked about what's reasonable. There are over 300,000 mandatory community associations in existence in Texas. So this is not new.
No.
Well, I take that back. There's 300,000 in the United States. There's 30,000 in Texas.
Okay.
So this is not this comes up all the time, and the questions I get primarily are about people that don't want to pay a fine on something that they don't feel like they have done wrong. Okay?
They've been unreasonable in
And
doing.
so they mark off, they'll send the bill in or whatever it is for their homeowner's assessment, but not the fine amount. And then the fine keeps accruing, and then all these sort of kind of goes back and forth. But anyway, would you agree that a man's house is his castle?
Yes, I would agree.
Okay. And when you lived where did you live, Colorado or was it Dallas?
Dallas.
Where you had a castle?
Both.
A kid house and a castle. And since your issue's already been resolved, what was your issue there?
Well, when we lived in Dallas, we lived in a nice neighborhood, and we wanted to put up a fence, part stone, with a gate. We had a circular driveway in the front, and we wanted a half stone wall with wrought iron inserts. And it was interesting because where we lived, everybody in front of us and to the right of us all had big, tall gates. And the people to the left of us didn't have anything in their front yard. They had, beautiful kind of rolling front yards. And there was a woman around the corner that lived in a tiny little brick home. And all the homes in this neighborhood weren't tiny, but her home was tiny. It was a tiny brick home. And she decided, we took the gate and fence that was there down. And as soon as we did, they went before the city, city planning committee, city planning committee, and didn't want us to put another one up, even to replace the one that we just taken down. And so it was
But
quite
what
an
were
ordeal.
what were the guidelines? Were you under a city planning ordinance or?
In Dallas, Texas, you can have a fence in front of your house in the front yard
Mm-hmm.
up to 4 feet.
Uh-huh.
Anything beyond that, you have to get a variance for.
Okay, so the people that had the larger castle-like ones that were tall had gotten a variance. Is what you're saying.
Well, no, they didn't get a variance. They
Oh.
just built it and nobody complained.
Okay, so that would be very similar to a homeowners association in the sense that
Yeah.
it happened and no one said anything. So obviously it was something that
They
they
waived,
allowed. They
right.
weren't going to enforce that.
Right. But then when we did it, the lady around the corner got upset.
And you hadn't even put the new fence up yet.
No,
Is that correct?
no,
Okay.
we just started working on it.
Mhm.
Got upset, complained to the city planning committee, and we went to a series of meetings
Mhm.
where she brought her attorney. I wasn't an attorney at the time. I wish I had been because things would have gone differently,
Mhm.
I think. But she brought her attorney.
Well,
and
you
they-
would have known your rights. You would have been
Right.
bullied. Mhm.
Right. I remember my uncle saying, you should have gone into that first meeting loaded for bear, and then you wouldn't be in this situation. And I just thought, you're absolutely right.
Yeah, but you're like me, and you're just thinking people are nice and they're
Well,
reasonable.
we just got
and-
we were appalled. By the end of it, we were just appalled that people actually behave this way.
And what people? The lady around the corner, or everybody, or
It was the lady around the corner and her attorney, and she said that she spoke for the entire neighborhood. Well, she spoke for, I don't know that she spoke for the entire neighborhood.
for
She
anybody?
spoke for
Sounds
herself.
like, yeah.
Yeah. And
Was she
we
jealous? I mean, what was the deal?
she had a very small house, and I don't know.
And y'all
I
live in
mean,
that palace around the corner.
well, a
Didn't you
lot
say
of
you
our
lived
neighbors
next
did.
to? Who were your neighbors? They were like some big.
Tony, Ross Perot was one of our
He
neighbors.
lives next to
Okay,
Ross Perot.
all right, but
Yeah, but you lived in a castle. Come on.
yeah, I did. But and I should have been able to put up a fence that
Over
went with
4
the house.
feet. If someone like me, I'd be jumping that thing when I go get my drainage committee stuff.
Yeah. But if you don't know how to handle a homeowners association or how to handle a group of people in your neighborhood that gang up against you or have one vision for the neighborhood and a bunch of other people have
Yeah, but
another
didn't you
vision.
say you originally had the support of a number
Yes,
of people?
we did.
And what happened?
They just got cold feet. They didn't want to get involved. At first, they were like, of course, you can do whatever you want. What's the problem? Look at their fence. Look at their fence. Look at their fence.
Uh-huh. But weren't they afraid that they were going to come down them on their big fences?
They didn't have, the ones that supported us that backed out didn't have fences.
Okay.
Uh,
So they were
they-
just not having
they-
a problem with what you asked for,
They
but
didn't
they
have a
didn't want to
problem.
get involved.
They didn't want to get involved. And the woman in the little red brick house described the neighborhood as a park-like setting.
Uh-huh.
And
She lived next to Ross Perot.
yeah, as a park-like boy, you should have seen his gait.
He had like a airline, airport.
Well,
Landing
yeah.
strip.
Well, actually, his house was pretty small.
Really?
But he had a lot of property
Yeah.
and very
I can see.
foreboding.
I bet he had a big gate.
Huge.
Yeah, because you got to keep people out when you're
Oh
Ross
yeah,
Perot. I mean,
and
you're
it was
the president.
black and all blacked out and all of that. But so in her mind, this
Got
lady's
Christmas Carol over there.
mind, no, did we? No, we didn't Christmas Carol in that neighborhood. But she had one vision, and other people had different visions, and she was just able to impose her vision. And
Mm-hmm.
I really think a lot of it is because we just quit fighting. We were so disgusted that this even went on.
Because you were thinking, just like we talked about before, this isn't reasonable.
right.
And life, there's more important things to life than nitpicking about something that an argument when really God has given us the landscape every morning that's different, and we should be appreciating what we have. So anyway, the kind of getting back on track to our homeowners associations, the regulation of land use, just with zoning as well as homeowners associations, is really important. No one can tell a person what they can do on their own property. That's just a basic premise of the United States. That's why people came over from England for
Sure.
religious freedom and to be able to do what they want on their property and not be, bullied by the government and over taxation and that kind of thing. But this is the most important key to homeowners associations. To preserve their property values, they should be able to regulate what their neighbors are permitted and prohibited from doing. So in other words, for your own subdivision, you should be able to, you don't want somebody to come in that's got, old toilet sitting in there. I think like they have that over there.
A refrigerator
25.
in
Yeah,
your
on the front
driveway,
yard or
yeah.
something, or something where the the ambiance of the appeal when you come in is bad.
Mm-hmm.
But this doesn't say there's nothing to say that when the gas station people come in behind you or somebody else comes in behind you that you have any alliance with them or any responsibility to them.
Mm-hmm.
It's only within your group that, just like the United States, like we shouldn't have. It'd be nice to help other nations, but we don't have a responsibility to pick up the slack for every other country in the world.
Right.
We should first make sure that we're taken care of,
Right.
and then be gracious. And if we've got, to be the generosity for mankind, I guess.
Mm-hmm.
Anyway,
Mm-hmm. Okay. Well, listen, we're going to take a quick break, and we will be back. You can listen to us watch us live on Facebook, just facebook.com/Legal Connection Show. We'll be right back after the break.
For those of you who like your partners, your gumbo, and your music salty, well, we're here to help with the music. Julie and Shay here, host of Lone Star Country Nights Thursday, your weekly dose of roots and Americana and all the music that makes this part of the country special. We stir in Western swing, honky-tonk, Zydeco, Texas blues, outlaw country, and put a pinch of red dirt, and then we smoke it over a slow fire. Then listen to the results Thursday nights on Conroe's 104.5 and 106.1 and worldwide at irlonestar.com.
Does your company have needs that can be met by an employee who is dependable, hardworking, enthusiastic, motivated, cooperative, respectful, and punctual? Conroe Independent School District Special Education Department can meet your needs by connecting you with potential employees that have been preparing for a lifetime of employment. We have numerous individuals seeking paid and unpaid work experiences. If your company is interested in seeing how we can meet your business needs, call Conroe ISD Special Education Department to find the best employees for you at 936-709-7671.
Lone Star Community Radio is looking for those who are interested in hosting their own talk show. With monthly and weekly slots available on Conroe's FM 104.5, 106.1, and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the message line at 936-647-3776 to take your first step into the radio world.
Welcome back to the Legal Connection with Toni and Cheryl. Today we are talking about homeowners associations. Okay,
Here
Toni.
is some law. Here, I think this is, what the Legal Connection's about.
Right.
One purpose of deed restrictions is to protect property values. It's only one, but that's probably the major one for most people in subdivisions. They want to make sure that their property value is enhanced with a cute little marquee in the front, and that somebody doesn't come out with a herd of cattle in their front yard that's going to crash through fence or whatever it is. There might be a safety issue or whatever the case may be.
Right.
However, violations of deed restrictions most directly affect the value of adjoining lots, and that's Cox versus Melson in Texas. And so basically, if somebody's griping about your lot, like the lady that was around the corner from you, you would think it would be the person that would be close to you or in your subdivision, not somebody on the outside.
Yeah.
Somebody on the outside doesn't have any right to come into your subdivision and tell you, particularly if you're not next to them and not harmed by it, what you cannot come do, because that's manipulative.
Mm-hmm.
Now, an owner, a really, really old, well-settled law in Texas is, an owner burdens his own land with restrictions because the fact that a like burden will be imposed on his neighbor's lot, and this will be beneficial to both. So basically, it's quid pro quo. If you move into a neighborhood and it's a ranch neighborhood, or you move into a neighborhood and it's like Westview and everybody's got massive zero-lot houses then that are all red brick, like in Greatwood, then that's pretty much your deed restrictions are going to say something like that.
Right.
Tanglewood, I was just reading they have amendments quite often, and I know a lot of people on that board. This happened that I was in companies, and these people were the presidents and vice presidents. We became pretty good friends. As you age, the people you work with now own companies, and they have a really good protocol on amending their deed restrictions, and they comply with what the wishes of the community are.
Well, that's great.
Yeah, which really works. They've got a system, and it works very well. But in a lot of communities, they don't have them, or they don't use them, or they're not enforceable, or you have a board that overextends its authority by creating rules that they have no authority to do, and that kind of goes toward, kind of what was happening with a lot of my clients. there is a great concern about this practice of changing deed restrictions without a member vote or without an agreement. You have to go, the proof is in the pudding. You go to that declaratory instrument with the covenants in it, which tells you how to amend your deed restriction. Statutes are usually created for the benefit of the homeowner, not the association, because you want less government rule. And you're not supposed to have government rule over your own property. That's why that's what the United States is about. So, but HOAs are now recording all kinds of things in land records which are not properly adopted. And they're making up the rules as they go and then saying that they are the rules because they're recorded. And this just is simply not the case. They can't say, oh, well, we have a quorum if 5% of the people show up and the board's there.
Right.
If it's in conflict with what your deed covenants say, and no covenant would ever, that would never be allowed for you to change it so that basically a handful of people could make up all the rules and they point to something that's of record that's simply not valid. So that's being an attorney would help to be able to read that. They can't, the laws that are adopted by boards without sufficient board members under the governing documents are not valid. Bylaw or covenants or deed restriction amendments that are adopted contrary to the deed restrictions, that contrary to their purpose, are not valid.
You're right.
And even if you have a statute, statutes, especially in this area, many times are ambiguous, and you have to go to the legislative intent, which almost always favor the landowner as the little guy, and the legislatures are just trying to help their constituents.
Right.
So if you go to that, there's a lot of wiggle room for all the statutes, but you really want to go to see what your declaratory document says, and then you want to look at it in conjunction with the statutes. But the most important thing is, what does the community want? And if it doesn't harm the community, and actually it doesn't harm them, and it may actually enhance the values within your community, then then the board should probably comply with the wish of the community. So they shouldn't be able to override that for some political reason or whatever. Now, so what happens if there's improper records filed? What can the homeowners do? What kind of legal actions can they take? Well, the problem is that if your homeowners association starts, sues you, then they're going to, the money trickles down to the homeowners associations unless there's some kind of an insurance policy, which I think would be a good idea for associations to get, that would cover the cost of those kind of suits, sort of like an errors and omissions. But to blackmail an owner that's simply trying to have their deed restrictions, to have what they're doing, to be able to do what they're doing, and they're in compliance with their deed restrictions, and then be bullied by the threats of court costs and people rallying behind them, then that's on the association, or basically it's sort of legal blackmail by the homeowners association. That's not right, and so there are things that you can do. Now, what are the to get back to deed restrictions, because that seems to be a really big thing with a lot of my clients. Why do you have deed restrictions? Let's just go back to the basics, people. They set standards for the community, not communities on the outside, but the interior
for that
communities, right? So the lady that was dealing with you, the only problem is you had a zoning issue with Dallas, so that was a little different from the community. So I think that you might have had a good argument, though, because your community, you were telling me about how it looked on the street, was different one way than the other, and you had people that were so wealthy that they had likely had airline landing strips or that kind of thing there, that it was, the circumstances were different from what the zoning may have suggested when it was put together.
Actually, she was the only little house in the whole area. Yeah, I think that was a big part of it. But it really goes to the reasonableness of what we're talking about, that one person can try and manhandle the entire
and everybody's
situation.
Afraid because they're making a lot of noise and costing them money, and they just want to get on with their lives. They've got other things going on.
Right.
Now, the deed restrictions are critical in the importance without zoning. This is different here in the Conroe area than it is up in Dallas because we really don't have zoning. And so we have to rely on
the zoning in Houston is all over the planet.
Very different. But here up in Montgomery County, it's a little different because we're still a treed, forested area. And there's still a lot of arguments, though, about, what you can do on your property, but it's relative to the restrictions that run with the land as opposed to the zoning. Now, then another reason to have them is the necessity to maintain and improve property values in the neighborhood. And that's pretty much the main thing that people look at. So if something's going on outside the neighborhood that may be affecting you, then your homeowners association should step up to the plate and protect the homeowners within your association to make sure that your property values stay intact. And that kind of goes toward like Tanglewood, because back in the day, Tanglewood wasn't the affluent. I mean, it was still a wonderful place, but it wasn't like River Oaks back in the 60s. But it became that way because they protected themselves from outside influences by building, getting with the homeowners and building amazingly beautiful walls, and then putting together, like the amendments that I was looking at, restrictions that really kept everything intact as far as curb appeal and their property values. And that was the other main thing with Tanglewood, the curb appeal. And so if stuff's going on in a property that's kind of behind the scenes, then that's not curb appeal.
Right.
And there's a lot of that kind of goes back toward whether your restrictions can be enforced if something's going on that nobody can see. But your property values being maintained within your subdivision and maintaining curb appeal is really important, is the reason for deed restrictions, and to enhance and maintain property values. And the deed restrictions set guidelines for communal living within the association. And so that kind of goes back to the thing that we talked about before. Your neighbors adjacent to you, if you've got like, I guess if you've got like a pig farm and it's really smelly, that might be something that you would want to bring to the attention of your homeowners association, because you wouldn't have good communal living if somebody was doing that. A lot of the deed restrictions coming out right now, and some of the more fussy neighborhoods are not allowing you to have what's called solar clotheslines, and all that is a clothesline.
Oh, really?
Air dried by the sun.
By the sun.
And they're not allowing them to have that. In the country, I mean, that's not something that's come up with any of my clients. I was just reading about it. They've actually had lawsuits over solar clotheslines, which is kind of silly. Okay, so to get into to kind of move along to some of the more important issues. Now, what the authority to enforce deed restrictions? The association may collect attorney's fees and costs for enforcing government documents if there's written notice. The written notice is provided that a violation and it continues. This is only through the association. An owner is not liable for attorney's fees if the attorney's fees are incurred before the conclusion of the hearing under Texas Property Code .209.007. And this happens so much where somebody will say, you're not in compliance with the deed restrictions, and then they file suit, and then the person is trying desperately to get in compliance, and they do. Well, they're not responsible for the attorney's fees by statute, no matter what the declarations may say, because they're in compliance, and so it's moot. All right?
They fixed it.
So they've already fixed it, so that's not really an issue for that. Now, there was something I was going to talk about that was very, very important, and it goes toward voting rights. A lot of my clients were afraid that they couldn't vote, and were being told they couldn't vote because of their declarations, because they were not caught up on their payments, their assessments.
Right.
And the law changed, and that's just simply not the case anymore.
Well, good.
Under the Texas Property Code, and I believe it's 209.0059, might be 0055, but anyways, it's a 209. It's not, if you are behind on your assessments, or you're being told that you've got a deed restriction violation, that does not prohibit you from running for office, running for the board, or voting.
Well,
it does not
good.
matter what your declaratory interest said. That's a violation of your constitutional rights, basically.
Yeah.
And so you can vote. So don't let your association tell you any differently. And now here are some of the questions that I had from some of my clients, and they wanted to know did they look to their homeowners association bylaws and covenants, or did they look to the statutes? And so here's the answers. Under the Texas Homeowners Association laws passed several years ago, homeowners associations and property owners associations are required to make meetings of respective boards open. So the questions are, to answer what I was looking for was, who are the meetings open to? Because there's a lot of secrecy going on. And so who are they open to? The public? Can just anyone attend? Can they bring a lawyer? Can they bring the local news crew? Can it be recorded? Because people want to know what's going on. Because these things, as you know, and I've been to a bunch of meetings, and I kind of stopped going to a while, they can get really heated over the most minuscule, ridiculous things ever.
Right.
And it's almost like a family that's got some skeletons in the closet. They had this amazingly rich, wonderful, lavish wedding, and old Uncle Joe comes and the daughters come and everybody's all kiss, nicey, people they haven't seen for a while. It reminds me of an Italian wedding. But what's really going on behind the scenes, behind all the smiles and the sweetness, is a lot of pettiness. Uncle Joe's an alcoholic, and one of the sisters is got illegitimate children from 5 different guys, but she's pretending like she's married to some rich guy, and it's a wonderful wedding. And so there's a lot of things that aren't being spoken. There's a lot of secrecy going on.
Right.
And so the secrecy of the meetings, there shouldn't be secrecy in homeowners association meetings. It should just all be out there.
Yeah,
They're
there
just
should be
simply there to protect the
transparency.
value of the property,
Right.
protect the homeowners association from outside forces, whether it be government coming in and trying to, take eminent domain of your property or put an easement in, or that you want to be protected by your homeowners association, or whether your neighbors open a pig farm and you need somebody to come in and take care of that for you. Whatever the case may be, the restrictions are set out so that you can have communal living, curb appeal, and that your property values don't fall. And really, anything outside of that is just kind of nitpicky,
Right.
I think.
Yeah.
So anyway, the answer to that question about the meetings, though, is just the owners, persons who hold title to the property within the residential subdivision, and their personal representatives are entitled to attend. Not lawyers, but their personal representatives. If they
Well,
have
why would
property.
a lawyer not be a personal representative?
I don't know. I don't know why the law is set out like it is right now, but it seems to me that you could bring them, but I think you would have to get permission, because this is saying that you can't. But let me go on.
Okay.
Regular and special meetings must be open to all owners. Okay. Subject to the right of the board to adjourn and reconvene in a closed session. So they can do that. So if you're an owner or an owner's representative, like by proxy, and I would think an attorney would be appropriate too, but I don't know. They're saying not here.
Yeah.
You can attend the regular meeting, but if the board goes into a closed session, you're not allowed to, except for in these different situations. What matters are appropriate for a closed, or they're called executive sessions. Actions involving personal, pending or threatened litigation, contract negotiations, enforcement actions, confidential communications with homeowners' attorneys, matters involving the invasion of privacy of individual owners, and matters that are to remain confidential can only go into that by the request of the affected parties and by agreement of the board. Everything else is fair game in the special session. So all of these things should be open unless the person involved wants it to be kept, confidential.
And so the person involved can request that it's a closed meeting
Yes,
or an executive
yes,
meeting.
Right. And it says the new law now, the new laws back in 2015 require that owners be given advance notice of any special or any regular or special board meetings. The date, the hour, and the place, and the general subject matter have to be disclosed in the notice, along with the general description of any matter to be brought up in the executive session. The notice can be given in several ways, but the bottom line is the executive session has to be documented. Now, if the board is going to, this is the sort of the stuff that's outside of that context, though. If the board is going to consider or vote on any certain issues, the board cannot hold a meeting with, I'm sorry, let me say this again, because it's actually part of the statute. If the board is going to consider or vote on certain issues, the board cannot hold a meeting without giving the required notice to the owners. These issues include the imposition of fines, damage assessments, initiation or foreclosure or enforcement actions, except TRO or violations involving the threat of health and safety. Any other TROs can come up, it should be open.
Temporary restraining order.
Yes.
Is a
but
TRO.
Otherwise, it's got to be open to everybody to talk about it. It
Yeah.
can't be something that's hidden.
Right.
Increases in assessments are levying special assessments. Appeals from denials of architectural control approval. So that needs to be open to everybody.
Right.
And suspending a right of an owner before the owner has had the opportunity to attend a board meeting and present the owner's position. So if the owner has a beef, then they need to be able to present it to the board before it can ever go into an executive session. So since this is mostly what HOAs do anyway, they need to be able to, it needs to be open and not so much secrecy.
Right. And they need to notify all the homeowners in that association.
Right, there needs to be a notice, a proper notice. So because you need to get around the secrecy, it's not just Gestapo.
Right.
This is just a communal group that is put together to be able to keep
For your benefit, hopefully.
keep the benefit of the homeowners, not to make it so, protracted litigation and raising their fees and sort of blackmailing them by saying, well, if you do this and you ask for records,
We're gonna fine you.
We're going to make everybody pay. That's not the kind of things that you want to do if you're a homeowner. So,
Okay, well, we're going to take a quick break. our last one before the close of the show. You can send us your questions at legalconnectionshow.com, and you can also give us your questions on Facebook Live. We'll be right back after the break.
What is homelessness? Have you seen parents struggle to find a job without having transportation or childcare? What about the children sleeping in cars with nothing to eat? Families shouldn't have to struggle to survive, and children should not be homeless. Family Promise of Montgomery County serves the needs of homeless families and their children. Learn about ways you can help and learn about partnership opportunities at www.familypromiseofmc.org or call our day center at 936-441-8778.
Hey, Montgomery County and online listeners. Thank you so very much for checking out Jazzy Vibes with Soul. What? You haven't done so yet? Well, you've got to tune in. Hi, I am the host of Jazzy Vibes with Soul, Miss CeCe Holmes, and I invite you to check us out every Friday and Saturday from 7 until 9 p.m., where you will get the best in old school R&B and, of course, a little smooth jazz to make it jazzy. So tune in. That's right, tune in every Friday and Saturday right here on Conroe's 104.5 and 106.1 FM or worldwide at irlonestar.com.
A Lone Star Community Radio is Montgomery County's radio station with talk, music, weather, and traffic for Montgomery County. Have a question or comment about one of our shows? Want to know how to reach a host? Just contact the station at irlonestar.com or call in and leave a message at 936-647-3776. Get involved with your community with Lone Star Community Radio.
Welcome back to the Legal Connection with Toni and Cheryl. Toni and I are talking about homeowners associations. And Toni, you just went through the law about the homeowners associations. What about restrictions and enforcement of those?
If your homeowners association, if the board members and if you actually read your covenants, they're written not in legalese. I mean, you can pick them up and read them, you can get them off of from the property records. And again, just like we said before, sometimes what's in the property records is not actually, they didn't have the authority to file.
Right, they're not valid.
So you want to go to the restrictive covenants that are available to you. Maybe it's not the amendments, but you want to see if it was properly formed. Is it still in place? It's not hard to read. You don't have to be a rocket scientist to figure all of this stuff out. If you're even looking at that means you've had some you've had some interaction with your homeowners association, or you're buying a house, which you should look at before you buy a house.
Absolutely.
Without question,
right?
Because a lot of these lawsuits go toward people buying a property and tearing it down and wanting to rebuild, and they are being told for the very simplest things, like they want to face their house toward a different, not one street, but another if it's on a corner, and there's a different setback.
That's a big deal.
And
setbacks.
The setbacks are huge. And you may be in a community where your association and you bought your home, decades ago, but another association has come in and put their subdivision or development right next to yours with very lenient rules, where you may have a 50-foot setback. They have only a 10-foot setback. And so they are now staring down over you, and they may have pit bulls, and they may have, they may have all kind of things. They can put they can do all kind of things that do not help you and actually harm you in your association, because your rules have never been updated and your homeowners association isn't protecting you.
Right.
So you have to go look to that, and that's kind of where we're at right now. I've got a lot of clients coming to me with those questions. So interpretation of restrictive covenants. Go to your restrictive covenants and just read them. See what's of record. See what you were provided when you first bought your house, because those usually run with the land. And more than likely, if they are valid, and when you close on your house, you should have an attorney look at that to make sure. Then you just want to see, kind of what you're in for. And if you're already in there and want to see if you can update or modify, or like the lady in River Oaks, if your elderly mother now is in a wheelchair and you want to take care of her, you want to see what your your different positions are, what your options are. Now, this is the law in Texas. Interpretation of restrictive covenants. Free use of land, liberal interpretation, and reasonableness are the three key issues to interpretation. Free use of land to the owner, not to the association.
Right.
Okay. Liberal interpretation means if it could go one way or the other, it's going to be in favor of the homeowner. And reasonableness of what you're asking for. That's how the courts will look at this, whether it's a jury or a judge. Don't let your homeowner association put that black robe on and say they're the judge.
Right.
Because they're not.
Right.
Okay. But you also want to kind of weigh your odds too. Is this something that I want to fight over something really small when these people are being kind of petty about it? You know, your attorney will help you kind of work through that. Now, free use of land. For many years, the law as to the enforcement of deed restrictions favors the free use of land against those who seek to restrict the use of the property in cases of ambiguity. So if there's a question about what your deed restriction says, it's always by law right now, all the way up to the Supreme Court and our statutes, it should be interpreted in favor of the landowner. Okay. So if there's something that says you can't have guinea pigs unless you've got, I mean, this is just a stretch, guinea pigs unless you've got a kid that's under 10 years old. Well, let's say you had the guinea pig and now the kid is now 12 and they're saying you can't have it. Well, I believe that restriction would be in favor of the homeowner because at the time that they acquired it, they had a guinny pig and it was a pet. It's something
and the child was 12 or under, 10 or under.
You have to look at a lot of different things, but I'm just looking that would be reasonable,
right?
And if there's an ambiguity because there's no end to it, and so that would be my interpretation of it. Okay, liberal interpretation. Speaking of, a restrictive covenant shall be liberally construed to give the effect to the purposes and its intent, and that's in the Texas Property Code, Section 202.003. So even the statutes support that. What the intent was probably because it's for the benefit of the homeowner, not for the government, to allow you to have the free use of your property or have curb appeal or keep the property values up. Okay. The current balance in most courts, covenants should be liberally construed to determine the framer's intent. And if there is any ambiguity as to that intent, the covenant should then be strictly construed in favor of the free and unrestricted use of the premises. All right. Now, presumption of reasonableness. This is just a presumption, but like in law, you have to look at everything like the judge would look at it, all right? An exercise of discretionary authority by the property owners association or by other representative designated by an owner of the real property concerning a restricted covenant is presumed reasonable unless the court determines by preponderance of the evidence that the exercise of discretion is arbitrary, capricious, or discriminatory, okay? And that's important because you can't just say, I interpret it like this. You have to look at the way the law would look at it and kind of weigh how much it's going to cost you to go to court, right? So what's the definition of arbitrary? Failure to exercise honest judgment. So that is arbitrary. It's not, if somebody tells you something and you know that in their heart of hearts that that's just simply not reasonable and it's not judgment, it's biased or, someone's got a vendetta or whatever, then that's going to be arbitrary, okay? Also, I'm going to go to the interpretation of the covenants with regard to actual words used. The details and the devil's the details. The word vote is not defined in many deed restrictions. And if you look, so you have to go to what the actual what the common definition would be. And the word vote in like Webster's dictionary is just for an owner to establish what their position would be. And if I actually were to show you what the actual definition of vote is, which I want to, because it's just an example of the different things that you have to look at when you are trying to analyze on your own without trying to get an attorney involved so you can save some money, the kind of things that you're looking for. And gosh, I don't really have it right here in front of me, but look at the definitions of things that are actually in the actual covenant itself, because if there's something that you don't know the definition of, even the word subdivision is defined. Owner is defined. Go look at that because you don't have to be an attorney to look at that. That's all we learn in law school pretty much is, go to, you trace back to what the actual definition is and you look at it and you can reconstruct it. Now, capricious is another thing that you have to look for. That is freakish, whimsical, fickle, changeable, unsteady, and arbitrary, which is failure to exercise honest judgment. So being capricious happens quite a bit.
Right.
Just like in families. Which I think a homeowners association is kind of like a family in a way because you're all living together. Discriminatory, failure to treat all persons equally. And that goes to what we talked about before, where you've got somebody just like in your situation where you've got people with high gates
Mhm.
within the city and you have people
Mhm.
with low gates, but they're not all being treated the same. That's discriminatory. I think
Mhm.
that in your case, you could have argued that. Now, the other things are waiver and abandonment, and that kind of goes toward that. If your homeowners association hasn't, or the city or whoever the governing part entity is, if they haven't come to you and enforced whatever the deed restriction is, or they've actually have some rule that says we're going to overlook this deed restriction, then that's waiver and
Mhm.
abandonment, and it can't be. They cannot now hold the new owner or you down the pike.
They can't have it both ways.
They can't have it both ways.
Right.
You can't. You either enforce it or you don't, or it goes away.
Mhm.
Let's see. A waiver by definition is the court is going to the court will find waiver if a property owner association voluntarily, intentionally relinquishes its right to enforce deed restrictions
Mhm.
with some justification.
Kind of like the example that you gave at the top of the show, the beginning of the show, that was about the RVs. The guy couldn't park his RV in the front of the house, but other people were allowed to. So they randomly enforced that, and then the court considered it waived.
Yeah. So I guess this show is also to all my clients that are fearful, and yours too. I just happen to have a bunch right now, and I've got so many things to do, but you can't turn somebody down when they're in that kind of situation. This is for clients that don't believe they have any power. They feel powerless against their homeowners association, and some of the common problems are assessment abuses. This is very common with
Assessment of what?
assessment abuses. This is
Oh,
very
abuses.
common with homeowners associations. Assessments will be increased more than the rules allow. Assessment collections will far exceed the reasonable need. A
Right.
single assessment increased over several years and has accumulated a percentage. Management of company and attorney abuses. An unreasonable number of liens or lawsuits against owners by the homeowners association. Squeezing money from homeowners by threats of lawsuits and attorney's fees if they ask for certain records, or if they want to defy what the board, who are just volunteers,
Right.
have now said. Delegation of power to an attorney or management company to sue owners. Indemnification of attorneys and management companies so that owners pay for the bad acts of the management company. Management companies make bad decisions, and now because they're being vindictive, they're going to charge the whole association.
Right.
That's an abuse of the management.
Mhm.
Improperly creating late payments, waiting months before cashing a check, foreclosing when the homeowners or majority of the homeowners disapprove.
Yeah.
They said don't do it. Foreclosing agent that against those that are down on their luck. They can't be doing that. Foreclosing for trivial reasons. There's just so many other things that they do. Creating new deed restrictions without the voice of the owners.
Okay, Toni, we're going to have to wrap it up, but we want our listeners to understand these are common. And so
Yes.
if you see this happening to you, don't think, oh, they're picking on me. Know that these are common problems, that you have to stand up to these people. You can listen to us tomorrow. You can download us on Google Play and iTunes. We'll be here next week at 12 o'clock, and we want to remind you to
Serve God by serving others.
That's right. Have a great week, guys. Thanks for listening.